Thank you, Richard and Steve, for having me again and for this kind introduction. It's kind of really hard to believe that this is my third year in a row being up here and having the pleasure to speak with you at this conference. In fact, my very first public appearance as director of the division was right here at this conference, so fond memories. I really do appreciate your engagement with us and the staff, with me and the staff of the division, as we work together to modernize the regulatory framework for variable products. Products, as you know, that are really an integral component of our vibrant markets and that a very diverse group of investors look to when planning for retirement and their family's well-being. I'm going to age myself here a little bit, but in one of my very favorite movies, it's a 1986, I was in middle school. It was a hit movie, Ferris Bueller's Day Off. I'm not going to ask how many people here remember it. But Ferris Bueller said a line that, I think really can resonate here. Life moves pretty fast. If you don't stop and look around once in a while, you could miss it. The division staff has been working really hard on behalf of investors and has accomplished quite a bit since we last spoke. So it's important to stop and look around at the work the Commission and the staff have done and what we have accomplished on behalf of investors. A moment to reflect helps us evaluate what has been accomplished and what we need to do next. So today's conference is a perfect opportunity for us to do just that. So today I want to reflect on the usefulness of data required by our new forms, the Investor Experience Initiative, including an update on the proposed changes for the variable annuity and variable life insurance contracts, and the recent rule proposals aimed at modernizing how we regulate the asset management industry. Before I begin, I want to remind you that I'm speaking today only for myself and not for the Commission, the commissioners, or the staff. So in speaking to you at prior conferences, I often cite data. I'm a strong believer in data. I cite data as to the size and the pace of growth in the variable insurance market. And those statistics at that time typically came from trade group publications such as industry fact books. The use of statistics compiled by those outside the Commission was not just limited to the variable insurance market. The lack of in-depth data about the inner workings of the Commission's registrants, their investments, and the ability to easily spot outliers in the investment management industry was a concern for the Commission. With the filings of the first Form NSENS this year, I can tell you without having to look at outside data sources that, as at the end of last year, the Commission regulated 422 variable and annuity separate accounts, 241 variable life separate accounts, and that collectively these separate accounts funded about 3,500 variable products. I know that because you told us that directly. The data collection does not begin and end with the requirement to file the new information on Forms NPOR and NSEN, which were adopted, as you know, back in 2016. Rather, the information must also be reported in a structured data format. This modernized the delivery of information. That modernization is just as important as the information itself that we are receiving. With this rulemaking, the Commission moved from 1980s technology to a digital regulatory approach that actually makes the information more useful to the Commission, the markets, and investors. I have personally seen and used the data in formulating my opinion on a number of issues that the Commission is considering. It's truly amazing how helpful it is to receive the data in a structured format. By providing more useful structured data in these new forms, you're enabling us and the staff to better inform rulemakings and focus the Commission's compliance and inspections resources where they are needed. Moreover, the new information in the forms, such as on securities lending, derivatives, and ETFs, provide data that better describe the contemporary underlying market. These forms represent only one of a multiple initiatives we are undertaking to modernize our regulatory approach with respect to the asset management industry. So another initiative that we're undergoing at the Commission is trying to improve, and Steve, you touched on that a little bit, trying to improve disclosures to investors through the use of shorter, concise documents. These focused disclosures would be more accessible to Main Street investors, and it's my belief that these disclosures would provide investors with a roadmap so that they can better access the information they need to make informed decisions. One part of this effort touches the products you offer. So last October, as you know, the Commission proposed to modernize the disclosure framework for your products. I know you know this, the potential investor in your products is given hundreds of pages, if not more, of account opening and disclosure documents. Frankly, the resulting pile of documents can be so daunting that many may invest in these products without reading the documents. So without getting the information needed to make fully informed investment decisions. At the same time, as I mentioned earlier, your products are really the ones that many of these investors look to, rely on, to provide for income during retirement. And with retirement planning being so important to all of us, as well as the overall economy, the Commission decided to act to improve investor understanding. So the Commission proposed changes that reflected a comprehensive review of the entire regulatory framework. We reviewed statutory prospectus requirements, rules applicable to your products, prior staff statements in the space, and looking for places where we could modernize the framework. We also, in the proposal, it sought to modernize our experience with layered disclosure to date, particularly in the mutual fund context, and also the use of technology. And in particular, how the internet can improve the usefulness of information provided to the markets and investors. So as with mutual funds, the Commission proposed a layered disclosure framework. The proposal featured an initial summary prospectus for new investors explaining upfront a contract's important features, costs, and risks, and an updating prospectus that would be sent to existing contract holders to provide information on important changes that occur in subsequent years. Both types of summary prospectuses would use tables and high-level summaries to help make them more reader-friendly and easier to navigate. To further improve investors' understanding and disclosure experience, the proposed framework would also permit layered disclosure about the underlying mutual funds in the contracts. So certain key information about these funds would appear in the summary prospectuses, and others would be layered under. Together, we believe that all these changes would allow investors to obtain the information they want in the format of their choice, without the daunting task of having to navigate a pile of documents. So in addition to addressing the sheer volume of data that investors are confronted with, the proposal also sought to modernize the registration statements and the rules applicable to variable insurance products. So just as the Commission did with new forms NSEN and NPORT, the variable contract proposal included the use of structured data for certain disclosures. I think we can all agree that investors should know and understand the fees associated with their investments, including those associated with your products. In order to provide greater clarity to retail investors, the proposal would require the use of structured data for certain items, including the key information table. Using structured data would provide a way for investors, either on their own or through financial professionals or data aggregators, to analyze and compare information about the costs associated with other variable contracts or other investment products. So the proposal, if adopted, would establish a new disclosure framework for variable products. To make sure that investors had an opportunity to comment, we included a feedback form in this proposal, which we have used in other proposals this past year. We received over 50 comment letters and responses to our feedback form. The comments spanned, they came from retail investors, they came from insurance companies, trade organizations, practitioners, investor advocates, academics, so we had a really diverse group of commenters. We also met and had very productive conversations with different groups that had specific concerns and suggestions on the proposal. Overall, the feedback was very positive. Commenters generally supported the proposal's goals of providing layered disclosures, modernizing and streamlining the disclosure provided to investors, and embracing advances in technology in the disclosure framework. Let me share some of the themes from the comment process which you might find helpful. First, the proposal discussed several possible approaches for discontinued contracts and requested comment on these approaches. This issue in particular drew a lot of comments. A number of commenters requested that discontinued contracts be permitted to continue to rely on what's known as the Great West regime. In addition to comment letters, some concerned with this issue came in to meet personally with us and also provide helpful information regarding costs and effects of revising or rescinding this relief. A second area that listed good comment and debate was the use of structured data. Although several agreed that tagging key disclosures in statutory prospectuses using inline XBRL would facilitate product comparisons, some opposed this requirement. These commenters suggested that data tagging would not be helpful due to the complex nature of variable contracts and the vast disparities in the design of the different contracts. Third, many commenters were also concerned about the use of some of the proposed terminology in the disclosure documents. Although some supported specific terms or standardized definitions in the registration forms and the summary prospectuses, others voiced concerns. The other commenters asserted that some of the terms could be maybe confusing to investors who may be used to different terms in the contract documents or in prior versions of the prospectus. So where are we? The division staff, we are now working on developing a rulemaking recommendation to the Commission for adoption, taking into account all the issues raised by the commenters who so generously gave us their thoughts and their time during this process. In terms of timing, although I can't make any promises, I can tell you the rule is listed in the RegFlex agenda for final action by April of 2020. But in the meantime, although the formal comment period has closed, the staff will continue to consider comments and is always available and interested if you have ideas, concerns, or other information that you would like to share with us. The Commission's Variable Product Summary Prospective Initiative is only one part of the division's holistic review of disclosures with the goal of improving the investor experience and the utility of fund disclosures for investors so that, as I mentioned before, it's really important the disclosure allows them to make informed investment decisions. So this initiative has been a top priority and continues to be a top priority for the division. In June 2018, the Commission issued a request for comment on how to improve fund disclosures for the benefit of Main Street investors. As we were particularly interested in feedback directly from investors who use these documents, again, this proposal included a feedback form, asking everyday investors for their input on simple questions about how a fund discloses the information, how they use that information. Based on the feedback received from investors, the first phase of the Investor Experience Initiative will focus on improving shareholder reports and the disclosure of fund fees. I'm pretty sure that you would not be surprised to know that the average fund shareholder report is over 100 pages long. The size of these reports, I would imagine, likely discourages Main Street investors from even attempting to read them. Yet, they get them twice a year. We in the division believe that we can do better. The staff is currently considering options for a shorter and more engaging report that gives shareholders key information to assess and monitor their fund investments. Similarly, investors did indicate that the fee table was confusing. They said there were too many legal terms, line items in the fee table, and frankly, they were just interested in an understandable bottom line. So the staff is thinking about ways to simplify the presentation of fund fees. We're also considering ways to provide funds the flexibility to present disclosure using any technology or device reasonably capable of communicating the required information to investors. Ultimately, we want investors to be able to find key information, understand it, and use it to make their investment decisions. Improving disclosures to investors is not just our responsibility. You also play an important role. Later today, you're going to hear from staff members from the Disclosure and Review and Accounting Office. And I want to really emphasize the importance of maintaining a good dialogue between the division and market participants about what we expect to see in disclosure filings. I see this as a dynamic and ongoing process. Let me go off script for a second. I have said in many settings that one of the ways that you can really help us and help yourselves, actually, is get to know your disclosure examiner. And it doesn't have to be within the review of a particular registration statement. Disclosure examiners are typically assigned to a registrant, so you have that continuity. Having a conversation with them, explaining your business drivers, your business model, can go a long way to helping the examiner understand sort of how the framework for your business is. So it goes a long way. Please do consider getting to know your examiner. As part of this dialogue, the division has started to issue accounting and disclosure information staff documents. We call them ADIs. And these are intended to highlight some best practices. Over the past several months, the division has posted 3 such ADIs. The ADIs focused on automatic effectiveness of registration statements, registration amendments rather, and effective communication with division staff during that process. That was one. The second one was on improving risk disclosures, and the third one was on the performance and fee issues that the staff was seeing during its review of disclosures. We think these ADIs are an excellent resource and tool available to you. They're concise, and we believe they can help you improve communications with your investors. And I do encourage you to reach out to division staff with ideas for future ADIs and areas that you believe would be could use some further clarification. So that our efforts, the division and the commission's efforts on behalf of investors, has not been limited to disclosures required by our forms. They also include modernizing how we regulate. So just this week, the Commission proposed a wholesale update to the investment advisor advertising and solicitation rules, which were adopted back in 1961 and 1979. Just so we can all have perspectives on these dates, the internet was officially launched in 1983. In effect, the proposed rules would replace the original rules, the substance of which has really not changed since their adoption. The proposed advertising rule would replace the current rule's broadly drawn limitations with a more evergreen and principles-based rule that recognizes developments in technology, the changing profile of investment advisors, and our experience administering the current rule. It should also, we hope, accommodate future innovations in technology and the provision of investment advice. While the proposed rule carries forward its predecessor's general prohibitions on certain advertising practices, such as the current prohibition on any advertisement, any advertiser cannot contain an untrue statement of material fact or otherwise be false or misleading. But then in a principles-based manner, it recognizes the evolution of the marketplace and how investors look for and receive information. Along those lines, the proposed rule would, for example, permit the use of testimonials, endorsements, and third-party ratings, subject, of course, to certain conditions. Needless to say, these have become commonplace, commonplace uses in many parts of our everyday lives. The proposed solicitation rule would replace the current cash solicitation rule and would cover solicitation arrangements involving all forms of compensation rather than only cash. Importantly, it also would add a new exemption for de minimis compensation to solicitors to accommodate trends. recognizing that investors in the private funds may not be aware that the person soliciting them is being compensated by the advisor to the fund. Private fund investor solicitations would also be covered by the proposed rule. This proposed wholesale modernization of those rules, it was not an easy endeavor by any means. Over nearly 60 years, the staff has issued more than 100 no-action letters and other guidance on the application of the advertising and solicitation rules. This combination of outdated rules, along with the numerous staff letters, is, to say the least, a tangled web. Through no small feat on the part of the staff, we reviewed this tangle of staff letters and crafted a proposal that would streamline and update the rules. As an example, the presentation of performance in advertising is currently shaped by a complex set of staff letters. The proposed advertising rule specifically addresses performance and would permit the presentation of advisors' performance results subject to tailored requirements based on an advertisement's intended audience. The proposed rule reflects years of outreach conducted by our staff. We have met with groups presenting diverse points of view, including investor advocacy groups, advisor groups, practitioners, and others. However, we would greatly value all input on the proposed rules and on whether that they strike the right balance. In particular, we hope you comment on how the advertising rule deals with testimonials and performance, and whether it will provide advisors the flexibility they need in marketing their services to clients in today's technology-driven world. We will continue this dialogue not only in the traditional rulemaking comment process, but also through our feedback forms. As with recent rulemakings, I just mentioned two of them that had it. The Commission did include an investor feedback form in this rulemaking. So investors can tell us firsthand about their experiences with investment advisor, advertising, and referrals. Actually, our very first comment in the file hit our desks yesterday and was from an investor who was very appreciative of the form. For the first time, the Commission has also included a feedback form for small advisors. So small advisors can tell us how the rule would affect them. The development of this feedback form for small advisors was a direct result of our outreach meetings with smaller and mid-sized advisors. Smaller advisors in particular requested a tool that would assist them in providing us with feedback in an efficient and cost-effective manner. So both of those feedback forms are available on our website. We really do hope to hear from investors and smaller advisors so we can carefully assess the impacts of the proposed rules on them. We also hope to generally hear back from smaller advisors on the usefulness of the feedback form and whether changes going forward would be beneficial. Another focus for the division is looking for ways to increase the diversity of investment opportunities available to investors by addressing any unnecessary regulatory barriers. Having a diversified portfolio of investments is critical to making sure that investors are not too dependent on a single investment or a single type of investment. One example is our recently adopted ETF rule, which was originally proposed back in 2008. Allow me to start with a bit of personal history on this one. So my first job in the division was working in the office that was tasked with investment company rulemakings. And as a staff attorney, I actually worked on the rule that was proposed back in 2008. I left the commission after that proposal. A few years later, I came back, and I joined the office that was essentially charged with exemptive applications. The ETF rule, as you know, had not been adopted, and during my time in that office, I was part of the staff that looked at ETF exemptive applications. So I got to say, when I returned to the commission as director in 2017, I really did have the adoption of an ETF rule as pretty much one of the top of my wish lists. And I'm really happy to stand here today and say there is one less thing on my wish list, because we got that rule. The rule permits certain ETFs organized as open-end funds to enter the market without first having to obtain an exemptive order from the commission. The Commission also issued, alongside the rule, an exemptive order that harmonizes the related relief for broker-dealers. The ETFs relying on the rule would have to comply with certain conditions designed to protect investors, including conditions with respect to transparency and disclosures. So the rule and rule amendments would make it would also make the evaluation of ETF costs more straightforward by requiring all ETFs, not just the ones who would rely on the rule, to disclose ETF trading costs. Although most insurance company separate accounts do not invest directly in ETFs, the new ETF regime should increase the options for contract holders desiring a fund of ETFs structure for their invested assets. With the adoption of the ETF rule and the rescission of the ETF orders, the Commission Commission has created a level playing field for run-of-the-mill ETFs. As you know, over the decades that we've been issuing ETF orders, the conditions and the terms of relief have varied. In particular, some of the earlier exemptive orders allowed for much greater flexibility to the use of custom baskets. So I believe the new rule will increase competition in the ETF space and hopefully lead to continued growth in the varieties of ETFs offered to investors. So the ability of ETF sponsors to rely on the rule instead of coming through the exemptive process hopefully would reduce costs to sponsors, which hopefully would translate into more opportunity and choice for investors. And while just that by itself has freed up staff resources, the Commission recently went further. Recognizing the importance of the exemptive process in timely access to more investment choices, the Commission also proposed rule amendments to establish an expedited review procedure for applications under the Investment Company Act that are substantially identical to recent precedent. The proposal also would establish a new informal internal procedure for applications that would not qualify for the new expedited process and promote transparency through the public dissemination of comment letters. The proposed actions are intended to make the application process more efficient and transparent. So it's been great spending time with you this morning, and again, I apologize for my voice. And it's been great to stop and share with you what the division has been doing. And as you can see, and I only touched on a few projects, we've been very busy. The staff is committed to improving the investor experience and modernizing our regulatory framework, and that has been the focus of much of our work the past couple of years. And we're not done. We plan to continue focusing on protecting Main Street investors, whether through improving disclosures, including through a recommendation for adoption of the variable annuity summary prospectus, or helping new products come to the market that can be used to diversify investors' portfolios. We will continue to work on behalf of Main Street investors. The work of the division is truly, truly a team effort. I am really fortunate to have fellow division staff members dedicated to the Commission's mission. I'm going to go off script again for a moment, and I want to just highlight two staff members without whom the Investor Experience Initiative may have just been a figment of my imagination, a dream, and not launched. One is here today, Michael Kosoff. And Angela Mokadine. These are voluntary initiatives. Our board outreach, investor experience, and small and mid-sized fund outreach initiatives are completely voluntary. They are above and beyond our tasks, our daily work. So the staff members who are dedicating time and resources to doing this, they are doing this outside their regular plate of work. And their plate of work there's not much room. Actually, there's no room. Michael and Angela, they stepped up as team leads. They have a great group. In fact, our inaugural meeting, from what I heard, to get people really psyched to join the investor experience team, Mike got a conference room, got some donuts, and I think it might be our biggest team. But a lot of the work that you're hearing about in terms of disclosure really has been driven by the great work that Michael and Angela and the team they've assembled for the investor experience to do. And aside from that, by the way, on variable annuity products, Michael is also one of our lead experts in the division, so he is just a treasure, and he's right there. So I do encourage you to get to know him if you've not already. Some of my colleagues will be participating on panels later today. Many of the conversations that Steve has mentioned. So you have Seratin Sidov, Bill Katapish, Harry Eisenstein, Caitlin Botok, and Amy Miller. They will all be here with you today. So thank you again for the opportunity to be here to share the morning with you, and I really hope that you enjoy the rest of the conference.